Hello, welcome back to our revision session. In this session, we shall be looking at the December 2021 sitting of Advanced Taxation. So welcome and let's solve the questions together. So we start with question 1 of the paper. Question 1 in the current setting is mostly a theory question, and so be keen to be able to look at it keenly. It will always be testing a number of topics, majorly 2 to 3 topics in most cases. So question 1A of December 2021 Advanced Taxation says, as economies continue to recover from the impact of the COVID-19 pandemic, tax collection in many countries continues to face challenges. This trend has resulted in some revenue authorities resorting to some drastic measures to boost tax revenue. One recent measure taken in monitoring of social media accounts and postings is, to access taxation compliance. Required. Justifying your response with practical reasons, argue the case for or against monitoring of social media accounts to assess taxable capacity and compliance. Note, marks will only be awarded for one position taken. Now, this question is testing what we call emerging trends in taxation. So that reminds you to be keen on all the subtopics in that topic, including issues like high tax, COVID-19 and taxation, tax agents, tax experts, and all that. So in this particular case, we are looking at the impact of COVID-19 in taxation and what tax authorities have resorted to do for them to boost their tax collection. So let's pick the question again. Justifying your response with practical reasons, argue the case for or against monitoring of social media accounts to assess taxable capacity and compliance. And we are told marks will only be awarded for one position taken. So in this case, you were to take one position. That means you are either to argue for or against the monitoring of social media accounts by tax authorities to boost tax collection. But for learning purposes, I've looked at both sides of the coin, so I'll then be discussing arguments for and against monitoring of social media accounts. But in exams, please, in such a question, take one position and talk about it in detail. So one, I'm talking about arguments for monitoring of social media accounts to assess taxable capacity and compliance. Now, today, many business activities are done digitally. So then digitalization and rise of social media has changed the way businesses or other firms conduct their businesses. A lot of firms today do their marketing activities online. A lot of them conduct business and communicate with their stakeholders online. And therefore, the move by KRA and other tax authorities to monitor social media accounts helps such authorities to maximize on their tax administration, and therefore digitalization, in short, and the rise of social media accounts enhances the way people conduct business today, and therefore the move by KRA to monitor social media accounts is a new frontier in tax administration. Number two is that tax is a constitutional obligation that everyone has to bear fairly, and therefore all people must pay taxes, and therefore nobody is to pay a shilling less or more than what they should actually pay. And therefore, the move by KRA to monitor social media postings is therefore a good one to complement the traditional methods or traditional tools that were used by such authorities to ensure tax compliance and administration. Three is that monitoring of social media accounts supplement what we call lifestyle audit activities, such as wealth declaration by taxpayers, in order to determine whether such taxpayers are tax compliant or not. And through such audits, such authorities, including KRA, have been able to make or rather take enforcement actions against non-compliant taxpayers. In other words, I'm saying that monitoring of such social media accounts supplement or complement lifestyle audits by tax authorities to ensure maximum tax compliant by taxpayers. So those are some of the arguments for. And as I said, I'm looking at both sides of the coin. So the second bit, I'm looking at arguments against social media monitoring by tax authorities. One is that most tax regimes, including Kenya's tax system, is based on what we call self-assessment by taxpayers, founded on honesty and trust, where taxpayers are required to voluntarily disclose information about their incomes to their tax authorities. And therefore, monitoring of social media accounts by tax authorities goes against this trust and voluntary declaration of incomes by taxpayers. Two is that social media monitoring by KRA and other tax authorities goes against what we call freedom of expression through the Constitution, as well as other instruments like the international instruments, such as the Article 19 of the UN Human Rights Convention. For many social media users, their postings and communication through social media is just for fun and for keeping their friends informed about their activities and lives. And so, when KRA and other tax authorities start monitoring such social media accounts, it infringes the expression, the right of expression or the freedom of expression of such taxpayers. Three is that social media mining by tax authorities, including KRA, may or might punish those who cultivate false image of themselves in the social media or online. In some survey conducted by the British social media users, more than 75% of the people admitted that they were lying about themselves on social media. And that happens in Kenya and all over the world. Many people post information on social media which are not necessarily true about themselves. So today, for example, if I take photos in front of big mansions or big cars every single day and I keep changing them, if I post such on social media, that is not necessarily, may not necessarily be me. And so if KRA uses such information to determine or that to say that I'm not paying taxes as required, then that may not be true. I may end up being punished falsely just because I'm passing information on social media that may not be true about myself. So such as some of the arguments for and against the use of social media, or rather social media mining by KRA and other tax authorities across the world. That is part A of the question. The question is all theory, remember. So I move to part B of the question. It says, a delegation comprising government officials and entrepreneurs from a neighboring countries has visited your country, which is a beneficiary of the African Growth and Opportunity Act, AGOA, to learn more on AGOA and its benefits. A delegation comprising government officials and entrepreneurs from a neighboring country has visited your country, which is a beneficiary of the African Growth and Opportunity Act, AGOA, to learn more on AGOA and its benefits. Required: prepare a brief to be presented to the delegation covering the following. Prepare a brief to be presented to the delegation covering the following. 1 is background information on AGOA. 2, conditions to be considered as an AGOA beneficiary country. And 3, trade benefits provided under AGOA. Now, this is a question on the topic economic integration. Now, economic integration, in short, is simply the grouping together of countries in a given geographical region for purposes of promoting trade among themselves. Now that reminds you to look deeply into trading blocks, especially the East African Community, COMESA, and so on and so forth. But this particular one is on AGOA, that is African Growth and Opportunity Act, AGOA. Now, this is the background information on AGOA. AGOA is a piece of legislation that was approved by the US Congress on 18th May, the year 2000. AGOA is a piece of legislation that was approved by the US Congress on 18th May 2000. The objective of this legislation is to assist economies of the sub-Saharan African countries to improve the economy and to improve the economic relations between the United States and the region. AGOA completed its initial period of validity, and that was in the year 2015. And therefore, it was extended on 29th June 2015 by a further 10 years to 2025. Now, each year, the US President determines the eligible countries from the sub-Saharan Africa to be part of the AGOA. Then AGOA provides duty-free treatment to goods designated from such sub-Saharan African countries to promote the economic growth through governance and free trade. In other words, the aim of AGOA is to assist the sub-Saharan economies to grow and promote trade between that region and the United States. So the key points to note here is 1, the formation of AGOA. Number 2, the countries forming AGOA. And 3, the key objective of AGOA. So let me pick it again, as you may be noting. Number 1, I've said that AGOA is a piece of legislation that was formed and approved by the US Congress on 18th May 2000. The objective of the legislation is to promote and assist the economies of sub-Saharan African countries and to improve their economic relations with the United States. Then AGOA completed its first 15-year period of validity in 2015 and was further extended by 10 years to end in 2025. Then each year, the US President determines the eligible countries from the sub-Saharan Africa for the AGOA. Then how does AGOA benefit such countries? So lastly, I've said that AGOA provides duty-free treatment to goods of designated sub-Saharan African countries to promote economic growth through good governance and free markets. In other words, if such a country exports to the US, then the US government will not be imposing duty, that is import duty, on such goods from such countries. And therefore, this will make these goods to be cheaper in the US, and therefore such countries will be able to export more and sell more, and therefore benefit more from such a trade. 2, still on that, is conditions to be considered as an AGOA beneficiary country. Remember, we have just mentioned in the first part that every year the US President has the authority to determine which sub-Saharan African country joins AGOA. Now, you could say this in response to this. You say, AGOA authorizes the US President to designate countries as eligible to receive the benefits of AGOA if they are determined to have established or are making continual progress towards establishing the following. In other words, the US President looks at this for a country to qualify as a member of AGOA. 1 is market-based economies, that is, economies based on trade and economic growth. Number 2 is the rule of law. Such countries must be following the rule of law to the letter for purposes of promoting welfare of citizens in such countries. 3 is political pluralism, that is political inclusion, a case where every single citizen in such countries has the political right to do as they wish politically, of course within the limits. And 4 is elimination of barriers to the US trade. That is, such a country must not be imposing any trade barriers between it and the US government. 3 is trade benefits provided under AGOA. That is, what does a country benefit to be, from being a member of AGOA? So you can say the following are the trade benefits provided under the African Growth and Opportunity Act. 1 is promotion of economic growth, of course, through trade or increased trade between the country and the US government. Number 2 is promotion of political reforms. And remember, one of the conditions to be met by a country to qualify as a member of AGOA is political pluralism and the rule of law. And so through AGOA agreement, there is promotion of political reforms in such sub-Saharan African states. 3 is improve U.S. economic relations in the region. Remember, one of the conditions, again, that must be met by a country to become a member of AGOA is elimination of any barriers to the U.S. trade. And so, by eliminating such trade barriers, such countries are able to have improved U.S. economic relations with themselves, which further promotes their economic well-being. That was part B of the question. Part C, still a theory, is saying alternative dispute resolution, ADR, is a method of handling tax disputes outside the judicial process. All applications for ADR should be through a suitability should go through a suitability test before the application is submitted for ADR. Let me pick that again. Alternative dispute resolution, ADR, is a method of handling tax disputes outside the judicial process. All applications for ADR should go through a suitability test before the application is submitted for ADR. Required: 1. Summarize the disputes that may not be suitable for the ADR mechanism. And 2. Describe the documents that must be submitted to support and facilitate the ADR discussions. Now, this is one of the emerging trends in taxation again, alternative dispute resolution mechanism. Now, as a measure to promote faster delivery of justice by the judicial system in Kenya, the government introduced what we call alternative dispute resolution mechanism, ADR. Now, this is basically any mechanism of solving or resolving tax disputes outside the normal court process, outside the normal legal process. So the question is, part A, summarize the disputes that may not be suitable for ADR mechanism for 3 marks. So you could say this, you could say the following are disputes that may not be suitable for the ADR mechanism. The following are disputes that may not be suitable for the ADR mechanism. This is as per the ADR framework in Kenya. 1 is disputes or suits which involve interest of the public or interest of several persons who are not parties before the court. In other words, ADR mechanism may not be applied in case a party to a dispute is not before the court. In other words, for ADR to be applicable, all the parties involved in such a dispute must be able to present themselves before the court. And if such a dispute involves the interest of the public, then such a dispute cannot be resolved through ADR. Number 2 is election disputes as to public offices. That is, disputes involving election issues that entail election of individuals to public offices, because that again is has public interest in it. And so any party, any dispute that involves or touches on the interest of the public cannot be resolved through ADR. 3 is proceedings which involve prosecution for criminal offenses. So criminal offenses cannot be resolved through ADR. In criminal offenses, it is the state that resolves the disputes, and so the individuals will have to go through the normal court process. 4 is special cases which involve protection of courts, such as claims against minors, deities, and mentally challenged. Remember, these are special groups which may not be able to participate effectively in the ADR process. So such special cases which involve protection of the minors, protection of the courts, such as claims against minors, deities, and mentally challenged, must go through the normal court process facilitated by the government itself. 5 is cases which are related to serious specific allegations of fraud, fabrication of documents, forgery, and even impersonation. So such cases or disputes must go through the normal court process or the normal legal process, and therefore ADR is not applicable in such cases as per the ADR framework in Kenya. Part 2, the same, is asking, describe the documents that must be submitted to support and facilitate the ADR discussions. Documents that must be submitted to facilitate and support the ADR discussions. 1 is a summary of the issues in the dispute. That is, the particular issues which are being disputed in that particular case. So then the parties involved in the dispute must present to the court a summary of such issues that are in dispute. Number 2 is the relevant assessments, of course, in this case by the legal system. 3 is a notice of objection and all documents submitted to the commissioner. If there is any party in the dispute that is objecting any of the issues presented in the dispute, then a notice of such an objection must be submitted to the process. 4 is the objection decision, that is, the decision arrived at as a result of the objection. Another one is a settlement proposal with basis in the law as may be appropriate, if any. That is, any proposal by the parties on how to settle the dispute before the ADR process. And lastly, any other documentation as may be required during the ADR discussions. The court may require or order the parties in the dispute to submit any further documentation. So in that case, such documentation become part of the requirement to process and facilitate the ADR process or mechanism. That answers question 1 of the December 2021 paper. Remember, in the current setting, I said question 1 is solved theory, and in most cases it will test you on 2 or more topics at the same time. So be keen, especially on the issues of current trends in taxation and any other tax theory. That answers question 1.